Okay, good afternoon, everybody. My name is Jess Peake. I'm the Director of the International and Comparative Law Program and the Assistant Director of the Promise Institute for Human Rights at UCLA School of Law. I'm delighted to welcome all of you to this important event where we will be discussing why access to abortion is a human rights issue. This event is co-sponsored by the Center for Reproductive Health, Law and Policy, the Promise Institute for Human Rights, the Critical Race Studies Program, the Emmett Institute, and the Center for Immigration Law and Policy. This event today is part of a broader Visions of Reproductive Justice event series convened by our new UCLA Law Center on Reproductive Health, Law and Policy. There will be several other events in the series, and the next one is actually next Wednesday, February 8th, on Birthing While Black, which will explore the intersections between reproductive justice and racial justice. I think my colleague is dropping a link for that event in the chat if you would like more information and to RSVP. We really encourage you to join. For our event today on why access to abortion is a human rights issue, we have three fantastic speakers to lead us through this conversation. Macarena Says and Jamie Todd-Gear were originally programmed, and we have a third speaker, Tara Demant, who is a last-minute substitution today, as unfortunately our other two scheduled speakers, Radha Savena and Mary Hansel, were unable to join us. Tara, thank you so much for joining us at such late notice. Our first speaker today will be Macarena Says. Macarena is the Executive Director of the Women's Rights Division of Human Rights Watch, and she is an internationally recognized expert in gender, sexuality, family law, and human rights. She comes to Human Rights Watch from the American University Washington College of Law in Washington, D.C., where since 2010, she has been a full-time faculty member in the International Legal Studies program, where she taught family law, strategic litigation in international human rights and vulnerable populations. Our second speaker is Jamie Todd-Gear. Jamie is a human rights lawyer with over 2 decades of research, litigation, and advocacy experience on sexual and reproductive health and rights, sexual rights, and gender justice. Through various roles at Amnesty International, UNAIDS, the World Health Organization, and the Center for Reproductive Rights, Jamie has functioned as a subject matter expert and thought leader on issues of sexuality, gender, health, equality, and non-discrimination. And she's engaged directly with and advocated on behalf of those most marginalized at the global, regional, and national levels. Our third speaker is Tara Demant. Tara is the Interim National Director of Programs, Advocacy, and Government Affairs at Amnesty International, and she has over 20 years of experience in global gender justice issues and has advocated for human rights at the UN, the White House, the State Department, the Department of Defense, USAID, Capitol Hill, and with many foreign governments. In her current role, she heads the organization's work, Amnesty's work, on women's rights, LGBTI rights, Indigenous people's rights, and sexual and reproductive rights. Each of our speakers is going to spend around 10 minutes giving some opening remarks, and then we'll move to a Q&A format. So I encourage you to please put your questions into the Q&A function on Zoom, and I will get to as many of the questions as I can. Before turning things over to Macarena, Jamie, and Tara, I wanted to provide some very, very brief context for our conversation today. As we know, access to abortion is a heavily contested issue. Here in the United States, last summer, the Supreme Court issued a decision in Dobbs v. Jackson Women's Health, overturning almost 50 years of precedent established in Roe v. Wade that guaranteed the right to abortion because of an implied right to privacy under the 14th Amendment to the Constitution. In Dobbs, the court was asked to rule on the constitutionality of a 2018 Mississippi law banning abortion at 15 weeks. The court upheld that Mississippi law and held that the Constitution does not protect a right to abortion, nor is such a right deeply rooted in the history of the US. That decision triggered the implementation in several laws in different states in the US, most of which prohibit abortion at any stage of pregnancy, except in very narrow range of specified circumstances. Happily, some other states reacted to the Dobbs decision by passing state constitutional protections for abortion access, including California, Vermont, and Michigan. Of course, access to abortion is not only a US issue. It is a challenge faced by millions of women, girls, and people who can become pregnant worldwide. In fact, the World Health Organization suggests that 40% of people of childbearing age live in countries with either highly restrictive abortion laws or even where abortion is legal, it is neither available nor accessible. Happily, again, we have seen some advancement of abortion access and reproductive rights elsewhere in the recent past, including Ireland, South Korea, Thailand, Argentina, and others. And I think we're going to get into much more discussion of those examples in our conversation today. Reproductive rights, or the ability to decide if and when to have children, are grounded in international human rights. International human rights protect our human dignity and our right to bodily autonomy, that is, the right to make decisions that affect our own bodies. And under the international human rights framework, everyone has the right to life, the right to health, the right to be free from violence, discrimination, and torture or cruel, inhuman, or degrading treatment. And states are obligated to respect, protect, and fulfill these human rights. These rights are protected in a variety of international human rights instruments, including the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of Discrimination Against Women, and many others. All of these rights are threatened when women and people who become pregnant do not have access to safe abortion practices, because, as we know, outlawing and criminalizing abortion does not end abortions. All it ends is safe abortions. In fact, the World Health Organization reports that unsafe abortions are the third leading cause of maternal deaths worldwide. Access to abortion services is basic healthcare, and it should be available to all persons who can become pregnant to ensure that human rights are protected. With that very, very brief background, I'd like to invite Macarena to talk about her work with the Women's Division of Human Rights Watch and some of the strategies Human Rights Watch is employing to advocate for reproductive rights worldwide. So Macarena, over to you.
Thank you very much. I'm delighted to be here, which I hope that will be a good conversation. So my remarks will be brief, and hopefully we will have time for a Q&A later on. First of all, I wanted to give you a little bit of a framework of what has happened with abortion around the world and the role that Human Rights Watch has played. What I think it's interesting about Human Rights Watch is that it's a global human rights organization. And just like with the role of Amnesty International, it's very, very important that organizations that work on human rights in general have a strong work in abortion rights, because it's the best way, or it's a very important strategy to cement the narrative that abortion is an issue of human rights, and that access to abortion is an issue of human rights. And so it's not just, or just like when I say just, I want to make sure that I put it in quotation marks, because I don't want to say it as just one thing. But I think it's not a thing. Abortion shouldn't be an issue that is relevant for women only, or that only women's rights organizations work on. It is one of the central issues for the advancement of women's rights, of course, and autonomy of women. But it is an important issue on human rights in general for everyone. So first of all, that's why I think that it's important that organizations that deal with human rights, with everything, with the traditional issues of human rights, such as freedom of expression, the anti-democratic institutions, etc., really have a focus on abortion. On that, I also want to say something else that is related to the issue of human rights. We tend to still, until today, kind of have a separation between working on abortion, on working on women's rights, and working on anti-democratic situations or tendencies, authoritarianism, as if it were separate things. I think that this is the time, that it's about time that we do make those connections, that the restrictions on abortion are authoritarian moves. Even in democratic regimes, when a government restricts, or legislations, the rule of law restricts legally the access to abortion, we have to think that those are moves that contribute to the erosion of democracy. And it is a sign of a weak democracy, I believe. So I think that in addition to really working on how we move and we debunk the barriers for women to access abortion, it's important to understand that this is an issue that is at the core of democracy and human rights. That's one of the first things. The way that Human Rights Watch has been working on abortion, it has been basically supporting local movements and being good allies to organizations and local and the strategies, regional and local strategies in different countries. I think it's very important to understand that global organizations in general, we have a responsibility to not lead, but to be not in the driver's seat, but being in the side seat, depending on the strategies that local organizations are using, and we have a voice when it's needed. So what we have been doing is, for example, submitting amicus briefs or doing research in those places where we can show that how a particular regulation is impacting a specific group of people in a particular country. We have done that in several countries in Latin America, for example. What I think it's interesting from now moving forward is that Latin America is a great example of a region, as well, all regions I think are a little bit imbalanced, with some countries that are great and some countries that are really bad. But what it's really particular about Latin America is the speed of the progress into having access to abortion. And I think one of the great characteristics of the movement of what it's been called in Spanish La Marea Verde, the green wave or the green tide, that has allowed for this progressive legalization of abortion has been precisely the use of the human rights narrative by courts and legislators. So what it's interesting when for anyone who has been working on abortion in comparative law, for example, what it's really interesting is to see if you see the regulations regarding to abortion in the 1920s, or even the decisions regarding to abortion in the if there were a few, but when the things that were related to abortion or even contraceptives, etc., in the 1950s, even in the 1970s, there was like zero reference to women. Women were not at the center, not even at the periphery of those decisions or the way that the regulations were done. So women, as it is the case, unfortunately, in many parts of the world, were still viewed as objects that were means or tools for the protection of some other interests or other ends. And I think that that's the key issue of the obstacles to access abortion in many countries. The main recurrent argument is that women have to accept their destiny, and we don't have control as autonomous beings. We are tools for something else, for the interest of the country. And what you see in the last, let's say 20 or 30 years in Latin America is precisely a change in this idea that women's rights are human rights. And when we talk about abortion, this is something that happened to women, and that women are the ones who have to be, their rights have to be protected. Women are not objects of study, but are subjects of rights. And I think that is what has created a huge difference. We've seen it in the decisions by the Constitutional Court of Colombia, not only the decision from 2022 that decriminalized abortion up to 24 weeks, and so being like the strongest in terms of regulations on abortion in Latin America, but also we saw it in the Constitutional Decision Court of Colombia's decision in 2006 when it decriminalized abortion in the cases of rape, which was also very much women-centered. We see that in the decisions from the Supreme Court of Mexico that have decriminalized abortion in several states. Today, Mexico, out of the 32 states, have 11 states that have decriminalized abortion. And of course, there are several obstacles there, but the important news is that the Supreme Court in every case have used the narrative of human rights and has centered into women, in the experiences of women. And even in countries in Argentina, of course, that's the case as well in 2020, when through the legislator, it decriminalized abortion up to the week 14. But we also see it in other countries that have more restrictions to abortion. But you can see that the narrative is shifting, and it's allowing for more of a women-centered discourse. So we see that, for example, in Chile, where abortion was decriminalized a few years ago, only for 3 particular reasons, which is the kind of like the in-between, I guess, model. In the cases of rape, cases of severe fetal malformation that it's makes the fetus inviable. In the case of danger for the life of the pregnant woman. In those cases, still the way the narrative, in the Chilean narrative, has been women-centered. We see the same in Ecuador with the discussions today about whether it will be decriminalized. We see it, and the other thing that I'm going to say is that we also see sort of like this dialogue between courts and legislators, where we have a court that says we have to protect women and human rights, and we have to decriminalize abortion in certain circumstances at least, and then we have a legislator that responds to these. So I think that the strategies that the Marea Verde has been using in Latin America have been very successful. 1, because it has used the human rights narrative. 2, because it has really used advocacy and litigation strategies at the same time. So it has been targeting not only the legislation and the sort of like it's a political issue, but it also as a litigation issue based on human rights. And the third thing that I think it's been very, very important is working on the decriminalization of social abortion, not only in terms of how it is viewed by the law, but how it's viewed by society, what it means for women to make decisions, to allow women to make decisions. And this is, I think, a key element. The other issue that I wanted to speak, but I never know how long I have spoken. I always say that I'm going to have I'm going to follow.
You have about 2 or 3 minutes left.
Perfect. Okay. So the other thing that I wanted to very briefly mention is in terms of challenges for the future, because I think that we do need to we need to keep supporting this regional movement. I think that what has made the US an outlier has been precisely not only that this decision, the Dobbs decision, really could have been drafted in the 50s. There's like zero reference to women as a decision that it's centered on women at all. So it really, it's backward. It's a very backward narrative, but also because in the US, the narrative of human rights has not sunk in. So I think that there is something there of lessons learned from the region. But I think that one of the issues that we see around the world that it's important to pay attention is the issue of freedom of religion as a conflict with autonomy and access to abortion as an issue of human rights, of access to health, autonomy, etc. for women. And I think that that takes us to the regulation of conscientious objection. I don't have time here now at this in a few minutes to really talk about the obstacles of conscientious objection, but I'd be happy to later on in the Q&A to give a little bit more of information about how conscientious objection is being used as an obstacle to access of abortion and how it should be regulated in a way that is compatible with international human rights law, and it's compatible not only with access to abortion, but also with freedom of religion. Thank you.
Thank you very much, Macarena. You gave us a lot to think about, and we will definitely come back to that point of conscientious objection in the Q&A. Jamie, I'd like to invite you to talk about some of your work, particularly with Amnesty International and developing policies there.
Great. Thanks, Jess. And thank you, Macarena. I could not agree more in terms of this, this very interesting moment that we really, colleagues, allies, people working in the US need to look to what's happening in Latin America and the efficacy of advocacy, and also the challenges that continue to come when you have liberalization in abortion laws. And I know that we'll touch on that some more, but it's this moment where post-Dobbs, the US is trending and or on a trajectory completely backwards in terms of the progress that's happening in the broader regions. So I love thinking about how we can learn from colleagues and advocates in the global South in that regard. One thing I wanted to talk about and just really step back in that while human rights is an amazing frame to which, to ground our advocacy around abortion, it's important to understand the history, and that many of these foundational human rights treaties were developed in a time that didn't even conceive of women as rights bearers, of women having human rights, and that there was a lot of advocacy back in the day in terms of obtaining that recognition. As Macarena was saying, that things don't just happen to women, but women and girls and all people have human rights. And one of the wedge issues to try and get that recognition was, a lot of advocacy around violence against women and gender-based violence. And so when we come to this issue of abortion, and you look to those foundational treaties, you won't see the word abortion. The only international human rights instrument or regional human rights instrument that explicitly references abortion is the Maputo Protocol in Africa. So we've had to engage in decades and decades of advocacy to also, move beyond this violence frame, but also get recognition from treaty bodies, human rights experts, committees of, that are overseeing compliance with these treaties, to recognize how abortion fits within the broader human rights framework. And there has been a substantial evolution in that regard, and something that I really hope that people attending this webinar can be cognizant of, is that we've made leaps and bounds in terms of evolution of these standards, and recognizing human rights, or the full range of human rights is implicated by this issue of abortion. In recent years, what we've seen is that that treaty bodies have moved beyond thinking of abortion as, a limited issue, or an issue, well, we certainly need to stop maternal mortality, morbidity, and death and dying in terms of people resorting to unsafe abortion. That was the initial focus of human rights bodies. We're now seeing a greater recognition of the full range of conditions that require women and girls to access abortion, and the fact that women and girls and all people can become pregnant cannot access any of their human rights if they don't have control over their reproductive capacity and to make autonomous decisions about their lives and their bodies. So this is a shift that we're seeing in international standards. We're also seeing a shift from focusing on the individual, the pregnant person, to the larger, broader structural, social, economic, and political factors that either enable or constrain people to make decisions about their bodies. We're seeing clear guidance from human rights bodies in terms of states' obligations to ensure access to safe abortion and to remove barriers to abortion, to combat gender discrimination, gender-based violence, all of these issues that require people to need access to abortion, put people in situations where they have unplanned pregnancies. And we're also seeing that treaty bodies are recognizing that abortion is not simply a health service. It's not something akin to maybe an organ transplant or, access to dialysis, but it's this larger, it represents this larger issue of equality and non-discrimination, economic, social, civil, and political rights. So this is, in recent decades, this is the evolution that we've seen, and which makes this post-Dobbs world, now is the time to embrace the human rights framework in a way than we never have before. And that actually, this growing acceptance and taking up of a reproductive justice approach is really a call to taking a human rights approach. And we can touch on that in a bit. One thing I wanted to also talk about briefly, and building on what Macarena said, is the power of international NGOs that focus on the full range of human rights taking up the issue of abortion. And this is what Amnesty International, as one of the largest human rights institutions in the world, first adopted a policy in 2007. It was a big deal at the time for Amnesty to adopt this policy, and it came amidst its sexual violence or Stop Violence Against Women campaign, where the institution was advocating for prevention of and rights remedies for sexual and gender-based violence. And it got to a point where the organization could no longer, make its progressive calls without touching the issue of abortion, which it had avoided in the past because it was controversial. And in adopting this policy, it did lose some of its members, some who belong to the Catholic hierarchy, or some who felt it didn't align with their beliefs, but at the same time, it gained members. That first policy, like I said, was kind of mirrored what was happening at the international level with recognition of women's rights as human rights. It primarily focused on access to abortion in the context of violence. So it was a limited approach. It only called for access to abortion on certain grounds in certain cases. And it was kind of a siloed piecemeal approach to abortion, but it was what that institution could gain at the time. In around 2017, advocates, members, and Amnesty staff around the world started to call for an update of this policy because it no longer aligned with this evolution that I just spoke about of human rights standards around abortion. And it's important for international NGOs to take these steps because governments, member states, top-ranking officials, in some cases, give greater credibility when a large NGO takes up this issue than maybe a smaller NGO that they only work on sexual and reproductive rights. They might not be given the same credibility that a Human Rights Watch or an Amnesty International or any other NGO that works on the full range of human rights. So it was a big moment for Amnesty to recognize and reckon with the fact that its 2007 policy on abortion was outdated and did not align with human rights standards as they had evolved, and to recognize that if international human rights law and achieving human rights, the enjoyment of human rights for all people was truly its mission, ethically, it had to update its policy. So we had undertaken a multi-year process to review the policy, to review the evolution of international human rights standards, and to consider where the gaps were. And this was a real intensive process of going back and forth with Amnesty's national sections, dealing with the pushback and the nervousness and the people who were in opposition to this. It really forced Amnesty to go through this, this in-depth engagement process with all of its members, including people who are just not even staff of Amnesty, but members who pay dues to be part of Amnesty. Even they got to pose questions, express their positions, and to have the organization's international secretariat respond to this. So over the years, we eventually got to a place where we developed an updated policy, which was voted on within the organization, and eventually adopted and made public. And Jess, how am I doing on time before I go through? Because I can hold off and I can come through
2 or 3 minutes. Yeah.
Okay. So just to give a brief snapshot of where Amnesty's policy is now, and I'll put links in the chat for people, is that it moved from a siloed approach that only called for abortion in some cases to recognizing that and reinforcing that human rights are universal, indivisible, and interlinked, and that sexual and reproductive rights, including access to abortion, is essential to realize all human rights. It squarely places women, girls, and all people who can become pregnant at the center of the policy. So that's what will drive the organization's work. It calls for full decriminalization of abortion, post-abortion care, and evidence-based abortion-related information. This specifically requires removing abortion entirely from criminal and other punitive laws and policies, and to refraining from punishing people who access abortion, healthcare providers, and others who assist in people to get abortions. It calls for or reinforces international standards in that human rights protections begin at birth and do not apply prenatally. And it calls on states to fulfill the economic and social rights of all people, and to create the structural conditions through which people can exercise bodily autonomy. It's a principles-based approach, in that if any issue that arises in abortion when the organization is focusing its work on abortion is not addressed in this policy, that staff and colleagues can go back to the underlying principles and tailor their advocacy approach to their national context while still aligning with international law and the policy. So I can go into more detail on this, but what I would like to stop with is it's momentous that Amnesty International was both able to update its policy in a way that reflects the evolution of human rights, but also placed the organization to go beyond that and to continue to support evolution of human rights around abortion, and to make some calls that treaty bodies themselves have not even made. So it was momentous, and not to say that all is right in the world now, but I want to point the audience attention to these documents that I'll place in the chat, in the hope that they will be helpful for your advocacy and for rethinking how we talk about abortion in the United States within a human rights framework. And I'll stop there. Thank you.
Thank you very much, Jamie. That was a really good sort of overview of the evolution of human rights standards around abortion, and also very specifically how Amnesty has developed its thinking. And it's interesting to learn about some of the internal processes that went along with that. Tara, I'd like to invite you to talk about how Amnesty is using that policy as a tool in Amnesty's advocacy approaches. And perhaps if you could draw on some examples from non-Latin American contexts, as we heard a little bit about that from Macarena already, that might be an interesting counterpoint. For our audience, please do put your questions into the Q&A box, because we will be moving to Q&A after we've heard from Tara. Thanks.
Yeah, really happy to, and really pleased to be able to join, although I know Radha sends her regrets for her being ill. I mean, so there's a couple things I want to talk about the US context, specifically, obviously, in the way that Amnesty is approaching our work here, but also think about a couple of contexts internationally and the way that our work on abortion has been part of and aided the movement and the sort of trends that we've seen. So I think lots of people are well aware of the work in Argentina, hopefully also Mexico and Colombia. And you might also be pretty aware of the work in Ireland as well to liberalize abortion restrictions there. So this was actually, and sort of very much in line with the work of Amnesty to update our policy, was partly in response to work that was happening in Ireland and Argentina specifically, which was looking at the way that human rights law interpretation was actually very limiting for what we actually now agree is what's actually in international human rights law and policy and treaties, but also for the work that was trying to liberalize abortion laws in line with international human rights treaties. And Amnesty's policy was really standing in our way of engagement. Ireland is a case of this, where the section, so Amnesty International is an international organization. We have country sections. So I am here in the United States, our colleagues in Ireland are in Ireland, et cetera. And the Irish section had been working alongside reproductive rights organizations on a number of issues, but had found that as organizations were increasingly trying to liberalize abortion restriction laws there was a near total ban in Ireland that functioned as a functional full ban on abortion, that it meant that we were really bad partners for human rights defenders on the ground because we had this limited policy. And as Jamie said, ultimately a policy that was a misinterpretation or an incomplete interpretation of international law, policy, and practice. And so there's a case in which then Amnesty being able to be in line with what reproductive rights and reproductive justice organizations were saying, which were reflective of people's experiences, right? So as folks on the ground, as opposed to the policy nerds, you know, looking at documents, we're seeing is that people who were experiencing these restrictions were experiencing them in ways in which the sort of limited exceptions policy that we had it didn't work and it wasn't applicable. And that, of course, people who experience human rights, all of us are intersectional people who experience rights violations intersectionally. So there was an example where once, you know, as the policy was evolving, then our section in Ireland was able to mobilize with advocates on the ground, thinking about ways in which now, of course, the law had to be changed in Ireland, that international human rights law and policy could be useful. And part of that was in narrative change, right? So, and it depends country by country and context by context, but being able to say, you're out of step with international human rights law and policy can be very, very important and persuasive. In the Irish context, there was a number of different procedural votes that had to happen. The Taoiseach, like a prime minister, sort of needs to go through this process, and the bodied houses had to go through X process. But ultimately, you may remember that there was a referendum, which was a vote on sort of Irish opinion on abortion. And it was really, really critical to the movement to be able to make change here. And I think that's something that's actually really important to bring into this conversation, which is, of course, very focused on law and policy, but that alongside that has to be narrative and sea change in terms of how we actually make legal protections happen. They happen when there's enough will. And that can really stand in the way of important legal progression if there isn't the will for that. And it can help bring along legal progression when there is the will for that. And in Ireland, the groundwork on that was really incredible. The amount of narrative change work that happened that was obviously very contextual to the individual country and context, but also is really important as we think about other examples where international law and policy are part of the fight for abortion rights. And before I turn to the United States, I maybe will point to Poland, where we have, again, increasingly restrictive abortion laws. And I think back to Macarena's comment that, like, in a package of anti-democratic and anti-human rights laws, right? This is an increasingly anti-rights government in Poland that is using partly anti-abortion rhetoric and fervor to move forward its anti-human rights and increasing anti-democracy and anti-civil society laws that are moving forward. It will sound very familiar. They include sort of anti-gender laws and anti-trans laws and anti-abortion laws or rhetoric or policies, et cetera. So in Poland, part of the restrictions on abortion include parallel providing care or assistance to someone who is seeking or has sought an abortion. And Amnesty's work there has been really focused on cases where someone who provides information or access to abortion pills, for example, are now being criminalized. So in Poland, there's a case of a woman named Justynia who is part of an abortion advocacy group, and a woman who was seeking an abortion, who's in an abusive relationship and seeking an abortion, reached out to this organization that Justynia heads to get information. Her partner then got information, and as you probably know, most abortion surveillance is done by people you know or your doctor, although tech surveillance is something I definitely want us to talk about. Her partner then turned her into the police and Justynia, and now Justynia has been going through a really lengthy and convoluted trial process by which the conviction will include prison time, which is aiding and abetting abortion. And these are the types of places where, I mean, one of the things I want us to think about, especially you all, is how legally creative we have to be in terms of thinking how we actually make human rights law and policy real, right? It's one thing to have the treaty laws and to have all these strong and stronger spaces, which still need to be strengthened, of protections for abortion rights, but ultimately, how do we actually make them national law and policy, and having to be extremely creative about that. And in this case, it's like, what is the protection here for Justinia, right? What is the protection for an advocacy organization that is seeking to make sure people have their human rights? So the human rights defenders are also part of that. So that's been a really helpful space for Amnesty to be in, partly because we are not solely a reproductive rights organization. We are the full spectrum of human rights. So reproductive rights organizations in Poland and in Ireland have been working on these issues for a long time, but having Amnesty or Human Rights Watch or anyone who is like a broad and trusted voice on broad human rights sort of normalize that narrative, and also bring in these obligations, human rights obligations, to which Ireland, the United States, and Poland in this case are obligated. It has been and can be helpful. It brings us to the case of the United States. I did have a timer, which I do think I want to say a couple of things sort of briefly. One, that the anti-rights movement in the United States is extremely strong, it is extremely well funded, and is extremely nimble. And that is true, and extremely well organized. And that is not true of the pro-rights movement in the United States, particularly the reproductive rights movement. And what that means is that legal work and advocacy work outside the legal sphere can be a big game of whack-a-mole, where you're sort of popping up and seeing what's next. One of the things to think about, particularly in the legal sphere, is the way that we need to be much more forward-thinking in terms of the way that legal protections are going to play out in abortion. So the fall of Roe and Casey are obviously massive moments of rollback of abortion rights, but the way in which restriction to abortion is going to play out is through a number of other legal avenues, and that includes rights to privacy in terms of data, although again, most people are criminalized by someone they know or by the doctor or nurse. But rights to privacy and what tech companies are handing over in terms of abortion data or tracking data. It also includes thinking about, us just on a conversation this morning with a business and human rights group working with the financial institutions, working with some financial institutions, thinking about the things they're anticipating in terms of attacks on them legally if they are part of financing for abortion. If you think about the law, one part of SB 8 and SB 2 in Texas is the ability to then criminalize people who are aiding and abetting abortion, which includes financial institutions potentially. So what are the legal ways in which defense of abortion is actually going to be about defense of privacy or defense of financial, like the financial defense of Bank of America not pulling their credit card usage for if I want to fund the National Network for Abortion Funds, and Bank of America says, I don't actually want to, we don't want that liability down the road if the Texas AG comes for us, which they will. So those are something to think about too. The other avenue is a question of interstate commerce and and USPS law and places in which, as folks who are interested in human rights protection at the legal level, it is not just how do we try this case. There's a great question in the chat I hope we get to on the Inter-America's Human Rights Commission, although it is also that, and I'm very glad that lots of people will be working on that. It is also a question of how we think about anti-trafficking laws in the United States that are about to be used to prosecute people who might drive someone across a border for abortion. And there's a bill in the Missouri State House that is looking to do exactly that. And it may be quasi illegal now, but so was the Texas state ban, right, until Roe fell. So these are the types of legal avenues I think are important for us to think about, particularly as you're thinking about ways for your own practices and legal educations. What are the important things to think about? And the answer is everything, because the anti-human rights strategy is not just international human rights law and treaty, although it is also that, right? And so please be along with us in that journey there, thinking about the Unalienable Rights Commission, for example, in the United States, trying to sort of rewrite its human rights obligations. But it's also these very technical things that are coming up that we need to be able to navigate and think about really creatively. With 1 minute, because I know I'm over because I've put a stopwatch on, I will say that at Amnesty USA, our focus is on a number of things. As Macarena noted, it's so important that we are being led by the impacted people, which is a fancy way to say the people who've been doing this right on the ground, who've been leading rights work on the ground, who've been leading both reproductive rights and justice work and access to abortion work. And so the way we've thought about our strategy as an international human rights organization and a national body is how can we be uplifting the work that's going on at those levels. So we have state work, which will be focused. One will be trying to tie our activists and resources to states where opportunity opportunities to protect come up, where there are opportunities to combat bad laws that are coming, but also with 3 focus states, thinking about the ways we can add numbers to the ongoing work there. That is either, for example, trying to get a public referendum on the ballot in Arizona, or block or sustain a veto and block abortion bans in North Carolina. The other is continuing to fight at the federal level for, ultimately, the goal is, of course, federal protection, but that is a multi-decade goal. And so how are we building up towards that? Short term, it includes protections at the administrative level, and that includes through like the FDA, which is another area of law to think about, right? Like, it includes the FDA, it includes the Department of Justice, and it includes continued presidential commitments across like FEMA and et cetera, very creative ways to protect abortion, even though this right has been struck down. And obviously we're pressuring Congress. I'll talk a lot more about that if people are interested. It is interesting but tedious. But one place is we're also working a lot on the question of censorship of abortion and abortion information by companies like Facebook, by Meta, which is Facebook and Instagram, or by Twitter, which is another legal avenue to think about, right? The sort of role of technology in accessing your rights is huge, particularly in abortion. So I'm way over allotted time, but very happy for folks to be thinking creatively about ways to engage in this, and happy for more in the Q&A as well.
Thank you very much, Tara, and everybody. This was all really, really rich information, and there are so many different avenues we could take the questions. I think I'm going to turn, first of all, to the chat. And Jamie and Macarena, I think we're all back on screen now. If you guys want to pop your videos back on, great. So and Tara alluded to this, that there's a really great question in the chat about how the Inter-American Court of Human Rights is approaching questions of reproductive justice. And the particular question asks how the Inter-American Court should approach abortion under regional human rights law, particularly in the pending case of Beatriz versus El Salvador. I don't know if anybody, Macarena, maybe you know some specifics on that you could mention.
Sure. So I think that it has taken a while for, I mean, it's not true, but it's taken a while for the Inter-American System of Human Rights to really talk about abortion. But I think that it's important to consider that in 2012, I think it was, if I'm not mistaken already, there was a decision, Artavia Murillo v. Costa Rica, which was a decision that talked about IVF. And it's a very important decision because at that moment, in that decision, the Inter-American Court of Human Rights really talked about the interpretation of the American Convention of Human Rights about the right to life. And it said 2 things that are very important, and that informed also a decision from 2022 against El Salvador, the Manuela case, that will, of course, inform the decision that the Beatriz case against El Salvador will have. But what Artavia Murillo, the court said, was that, first of all, the protection of the fetus was a legitimate interest of governments, but it was not, it could not trump the right to any human rights of women, of pregnant women. And so from then on, there is an important interpretation about how the right to life should be viewed, that I think it's important. And then in the Manuela case, that was a case on obstetric violence, and it already also informed how a country has an obligation not to criminalize a person who's coming to, in a case of obstetric emergency, to a hospital. So, which is one of the entry points on criminalization of access to abortion when you have highly restrictive abortion regulations. So just to give you a little example of a comparison, before 2018, and forgive me if I'm wrong in the dates, I have a horrible memory for dates. So whenever Chile decriminalized abortion in the cases of rape, I mean, Chile had the strictest abortion criminalizations, just as El Salvador, Nicaragua, Honduras, Guatemala in Latin America. But the difference is that in Chile, doctors would not really denounce women who were coming with obstetric emergencies to hospitals to the police. It was very rare that that would happen. In El Salvador is the opposite. So what you have in El Salvador is cases of women who have been sentenced to 50 years in prison, 30 years in prison, who had miscarriages and had been criminalized not only for abortion, but for homicide of newborns, supposedly. So, but everything starts from the moment of what doctors, what's the obligations of doctors. And I'm not saying that doctors in El Salvador are evil and doctors in Chile are angels. But what happens is that you have a medical community that it's really afraid of being penalized if they don't denounce. And in Chile, you had a very robust and empowered medical community that said, we cannot send somebody to the police when they are coming to obstetric violence, for an obstetric emergency. And you had judges in Chile who had said, we cannot use evidence that has been given to a woman while she was in an obstetric emergency to a doctor. Whereas in El Salvador, you don't have that. So I think that what will happen in the Beatriz case, will be a follow-up of a very strong jurisprudence that started with Artavia, that then it came with Manuela in terms of restrictions or obligations that governments have to protect women in the cases of obstetric emergencies. So but the way that I think that it will come, if the court is consequent with its previous jurisprudence, is that it will hold El Salvador accountable for failure to protect women's rights. I think that there is another piece of information that it's important. It's an advisory opinion that came last year from the Inter-American Court of Human Rights on the treatment of women in prison, which also I think it's a piece of information that can inform the way that we should be looking at this. So I think that what it's interesting and important is that abortion, it's not an issue in silo, but it's a continuum of things that have to do with women's autonomy and respecting the right of women. And also to stop the narrative that this is a conflict between the right to protection of fetuses and the right of women to make decisions. The evidence is just too much out there that they are not, that actually the best way to protect fetal life as a legitimate interest of governments is protecting women's autonomy and regulating abortion and allowing for abortion to be legal and women should have access to safe and legal abortion.
Thank you, Macarena. And I'm going to pick up on, I think, two different threads that came through in your answer because they connect back to some of the other things that we were talking about. So first of all, you mentioned the 2012 Inter-American Court decision that was made in the context of IVF and the right to life. And I know, Jamie, in our earlier conversation, you were also talking a little bit about the parallels between abortion and infertility. So I just wanted us to sort of unpack a little bit that and talk about how those two issues are sort of reinforcing each other and some of the strategies that are being utilized in both. And so we'll turn to you for that question, Jamie. And then Tara, maybe you could talk a little bit about, I guess, what has been described as the chilling effect on healthcare providers and how, particularly in the US, how that is leading to more and more restrictive abortion services because medical providers are so afraid of being held criminally liable for performing abortion services. So Jamie, maybe you first, and then we'll move to Tara. And I do encourage everybody to continue putting their questions in the chat.
Struggling to get off mute. I just wanted to mention that building off of what Macarena was talking about in terms of claims for protections for fetuses in the state's state's interest in protecting fetal life, that Amnesty some time ago published a report that addressed criminalizing pregnancy, and it really gets into that the concept of how you can best promote state's interest in protecting prenatal life, and that the human rights problems when you create laws and policies that actually try to codify fetal personhood, which is rampant around the United States. And there was a question in the chat that there's analysis in this report about how you do the human rights analysis around health-related issues, and how do you confront these types of issues when the U.S. has only ratified and the International Convention on Civil and Political Rights and the International Convention on the Elimination of Racial Discrimination. So a lot of that analysis is in there for that question. In terms of thinking about the parallels between infertility and abortion, our lovely anti-choice advocates are also turning their focus to trying to restrict access to assisted reproductive technologies at the international level, and actually making some progress in terms of, and a lot of the argumentation is around establishing fetal rights and human rights recognitions around purported fetal right to life. So in an attempt to try and stave off these negative advancements and the opposition's tactics, advocates at the international level are trying to think about what is actually behind the issue of infertility, and which is, in very simple terms, one's inability to become pregnant and have a child. And behind that, or excuse me, what's behind the need for assisted reproductive technologies? It's this issue of infertility. And so when you step back and think about all of the human rights issues that come before that diagnosis of infertility, you start to see a whole panoply of human rights violations that have occurred prior to that point. And so when we think about infertility, just to give a bit more context, 180 million people around the world face infertility in nearly every walk of life, every country context. And it's been a bit of a neglected issue at the international level, but similar to patterns that we see in the context of abortion, what leads up to someone needing an abortion or wanting an abortion is an unplanned pregnancy. And when we want to take a human rights-based approach to abortion, we think about what is the larger structural conditions and what is the larger context in which someone has an unplanned pregnancy. So this is what we're doing in the context of why someone needs assisted reproduction. We step back. What is causing someone to become infertile? It's usually the cumulative denial of human rights, and whether it's states' failures to provide comprehensive sexual and reproductive health care, failure to prevent gender-based violence, failure to protect people from environmental toxins, laws and policies that lead people to resort to unsafe abortions. Multiple unsafe abortions can also contribute to infertility. We see that, and we see these larger structural issues, and we see a disparate impact on marginalized populations, BIPOC communities, migrants, people who are criminalized. These are the populations of people that suffer greater experiences of infertility. And we also see that LGBTQ plus non-binary people, some are experiencing biological infertility for the same reasons, but some are basically facing infertility because of the laws and policies that constrain their lives, that say that they can't, they're not permitted to create families that they want and have recognition of those families, or they can't access assisted reproduction. So we see, when we're stepping back and we're seeing the broader rights violations that lead to infertility, then we're in a stronger position to pull from and advocate from a human rights framework. this is the same for abortion. And this, thinking about the linkages between these issues, or that how they're parallel in some regard, helps to make the case for why taking a human rights-based approach to abortion is essential. Because a lot of our anti-choice advocates like to have us focus on that very moment of a termination of pregnancy. That's where they have their strongest strength for saying you're killing a human life. This person is committing wrong, committing a sin. A lot of these arguments focus on that moment in time without trying to, or not allowing for us to think about the broader context of this individual's lives. What has led, what cumulative denials of human rights have they faced led up to that moment? And what structural conditions are they living in that are discriminatory and actually put them in the place of not being able to control their fertility, not having access to the information and education to do so, not protecting them from violence, the whole range of issues that I mentioned. If we as advocates can step back from that moment of abortion to think about this bigger picture and frame it in human rights terms, I think that we can make greater progress in terms of shifting hearts and minds, convincing law and policymakers, and reclaiming some of that narrative.
Thank you, Jamie. And thank you both, Jamie and Tara have both been putting some really useful links in the chat to documents that they've been referencing. So do take a look in the Q&A box and also the chat for those. Tara, do you want to deal with this question of the chilling effect and medical providers?
Yeah, and I want to say two things first, and then loop me back if I get too off the course here. But one is to be really clear on what abortion restrictions do and are about, and they're about authoritarian control over your body. And that doesn't mean that you don't have a cousin or an auntie who gets really sad because of abortion and really believes in their heart that abortion is wrong. What people individually believe and the motivations that get them to support these laws are somewhat irrelevant to actually what the laws do, right? Which is, this is about authoritarian control over people's bodies. And it's really critical when we're thinking about this, particularly from a legal framework, to see that they are the exact same laws that prevent dealing and working through infertility, that they're the exact same laws that prevent healthcare for trans children, that they're the exact same laws that are using to attack, gender affirming care. They're all the same thing. Now, the sort of political force that drives anti-abortion, it is the same people and the same funding and the same playbook, literal playbook that is run by the anti-trans people, that is, so that's the thing. I think one of the tricks has been that it becomes, for many folks that are find themselves opposing abortion, they might not be thinking that because abortion makes them sad, or because they have a religious belief that I don't share, right? And so that's where this narrative gets really into, like you're saying, Jamie, the sort of point of abortion, or the moment of the termination of a pregnancy, that actually this isn't about at all. This is about who gets to make decisions about your body. The other thing that's really, really important, and I'm sure we all know this, is that abortion is routine healthcare. And it is something that, even as we're talking about it, what you might be imagining as an abortion is probably not a very likely scenario for abortion, or when a termination of pregnancy takes place. And without saying too much, I wanted to, my two sister-in-laws, both of whom have had abortions, and one of whom actually had to be like, oh, wait, yeah, I did have an abortion, because she had an unviable pregnancy that was pretty early on a threat to her health. And so she had an evac, but had not thought of herself as someone who had needed or actually received an abortion, because it was just her normal healthcare. And so that's also something, as we're thinking about political strategies moving forward, what does it mean to think about these, and legally in the spectrum of healthcare? What is it like? What healthcare decisions are being made here by whom? And what else does that mean, right? So and this is not the good abortion versus bad abortion. All abortions are a social good and a human right. But we're seeing increasing anecdotal evidence of folks moving in to receive cancer care. They find out they have cancer. They also find out at the same moment that they are pregnant, and then have very limited healthcare options if they live in Oklahoma or Texas or Mississippi or. So thinking about this again in the sort of spectrum of the legal spectrum that this can fall in, because the narrative, obviously the political narrative, is extremely anti-abortion. but like the actual laws are not, they're about healthcare, and they're about, you know, finance, and they're about interstate commerce. And so sorry, I mean, it's such a complicated legal issue, but it also means there's a lot of avenues for legal intervention that hopefully that you all are thinking about in creative ways. One of which is the freeze that we're seeing on medical providers. So Physicians for Human Rights has been leading a lot of this work, and I'm sure would be, I could send more information, they could send more as well, where they have already, because the legal scenarios are so complicated, because it is, again, a healthcare moment. Like, what is the point of intervention? A doctor or a practitioner can make healthcare decisions with the person who needs healthcare now is extremely complicated and not at all clear, because again, these rights these laws are not written by doctors. Like, they're written to be these political statements, and they actually make really complicated health impact in a way that is not intended. Now, the intended focus of cutting people off from abortion care is also enough and should not be happening at the level of human rights. But the sort of unintended consequences are, you have doctors and medical providers who not only are not sure if and when they can provide abortion care as people who, like, someone came in looking for abortion care, but if they are doing emergency medicine, like emergency medical providers, and you have someone who may or may not have known they were pregnant who needs emergency medical services, but those emergency medical services may or may not endanger a fetus that may or may not be viable, right? These are decisions that get made in the moment in terms of emergency care, or like cancer care. I think it's an easier one to think about, because cancer care, we maybe are all familiar with how long that might take and the types of chemicals that get used, right, that could potentially harm a fetus. So the reality is that you have doctors that are turning to the AMA and to their associations and for Physicians for Human Rights, looking for like immediate day of guidance. Like, I have a client, or I have a patient, pardon me, who XYZ, and then you have these healthcare organizations trying to move through what is really, really shitty health law, because it is not written to be good health law. It is written to be, you know, anti-rights, authoritarian law. So those are some of the complications there. The data is still, I mean, the data is coming in sort of day by day, but already that we're seeing that happen here in the United States. A lot of that was very well documented in Ireland, which was had some of the exceptions, right, where abortion was illegal except if the life of the pregnant person and the legal framing there was the life of the mother was at risk. And of course, the reality was no abortions ever happened, because of the fear of doctors having to then prove that what they did was 100% medically necessary to save this person's life. And it was, as folks may know, the case of a woman named Savitha, who'd really, like, her death was because doctors refused to intervene in a case that ultimately took her life, because they were afraid of being prosecuted, which is fair, because they likely would have been prosecuted had she survived. So there's lots of documented evidence in places like Ireland and Argentina as well, and other countries that I've been more engaged with. But in the United States, we're starting to see that. And I think, unfortunately, what we'll see is then in a year, we'll see these cases tick off, because there'll have been time to get them all documented. But we're already seeing that. Physicians for Human Rights and the AMA is documenting a lot of that.
Thank you, Tara. We have about 7 minutes remaining, and I definitely want to make sure we come back to Macarena to talk about conscientious objectors. So we'll do that first, but then I would really like us to conclude with a note of hope from each of you. So, you know, why are there reasons to hope given all of the horrific things that we're hearing today? So we'll start with Macarena, and then we'll move to Jamie, Tara, and I guess conclude again with Macarena's note of hope.
I can do both, so then we can save some time there as well. So I think that what it's the issue of conscientious objection, which is in the US is called freedom of religion. It's not necessarily, I think that the idea of conscientious objection has been used more in Latin America, and I think in other countries as well, in other regions. But as you all know, it starts with it's a construction that comes from the opposition to mandatory drafting in the army. So it's the idea that you cannot have a law that forces you to do something that your religion or your profound ethical beliefs would not allow you to do. And so in terms of the construction of this legal concept, it is a concept that fits within the concept of human rights, the idea of having the right to have profound ways of how you believe that the world should function, and the things that legal systems should not force you to do something that it's profoundly contradictory with your beliefs. The problem with conscientious objection when you move it from the military drafting to the issue of abortion is that it really has a huge conflict with another person's deeply important ways of living their life. You know, a forced pregnancy, which is the opposite of having access to abortion, is it's a profoundly violent act that has really complicated consequences in the long life plans of a person. So how do we make these two compatible is something that it is important to have an answer from an international human rights framework. And there has some things that UN treaty bodies or special procedures have said about conscientious objection in terms of that you should not, the protection of another right should not trump or should not be an obstacle to the protection of a woman's right to have access to a safe abortion, for example. But what it means in terms of the specifics, I think that there is a lot that international human rights law has to say yet on how we make sure that there is no incompatibility. So what we have found in the some of the research that we have done in Latin America shows that the problem with the idea, and this is Ecuador and Chile have been, especially Chile first, and then Ecuador has been following on the steps of Chile, is that conscientious objection, which is sort of like it's something that stems from a deeply held belief, is something that should have only access to individuals and not to corporations, for example. And yet in Chile, the Constitutional Court of Chile, when the bill on abortion was passed on this very limited bill that would allow abortion in sort of very specific cases, the Constitutional Court debunked the part of the legislator, the bill that would limit conscientious objection only for individuals. And it said, no, institutions also have a right to conscientious objection. And Ecuador is discussing also some sort of like this version of this institutional conscientious objection. So I think that the first thing is that we have to make sure that we understand that any legalization of institutional conscientious objection doesn't mirror any international human rights protection, because the freedom of religion is something that can only be applicable from an international human rights framework to individuals. And also conscientious objection or freedom of religion in this context, it's an exception to complying with the law. As an exception to complying with the law, it has to have a very narrow interpretation. It cannot be very broad. What we have found is that the way that it's being done, it's so open that instead of becoming an objection based on conscience, it's an objection based on convenience. So when the cost of objecting is so low, the cost of performing the service becomes very high. Because what you have is that you have particular areas, for example, in Chile, where in Chile, almost 50% of medical professionals have objected to providing the service. And so you have areas where there's no provider, or you have one provider. So what happens is that the cost of providing the service, the emotional, the time, even the economic costs of providing the service become way higher than the cost of objecting. If objecting only means to say I object, or putting your name in a registry, you know? So I think that there are some things that we need to really weigh in on how conscientious objection should be regulated. I'll say that because I ate up almost the time, and sorry, I won't say anything hopeful. I will leave it to my colleagues to say something hopeful.
Okay, pressure's on Jamie and Tara.
Thanks, Macarena.
Jamie, yeah.
Well, I think just very briefly is, in a message of hope, is like, look to our fellow advocates, allies in Global South, in Latin America. So much amazing progress has been made. in very, very difficult contexts where often, religious institutions hold great power, and there's a really strong unified opposition, that there are so many lessons to be learned from the creative, longstanding, committed advocacy to our advocates and allies there. And so let's try and reimagine what we can do here in the United States. We are in a very difficult context as well, but there are so many amazing ways that we can shift laws and policies, and that we really need to focus on changing hearts and minds, just as needed to happen in Ireland, in Argentina. But also, let's not forget what's happening in Latin America, because just as they've had amazing law reform, as Macarena is saying, this wave of conscience-based refusals, as I'd like to call them, objection, eviscerating access to abortion, once comes positive change, you continue to need to fight to ensure access. So, that's both, I guess, a positive and a moment of pause. Thank you.
Thank you, Jamie. Tara?
I'll just say I'm about to put in the chat the 2010 report on maternal health, as you talk about maternal health disparities in Black and Brown populations next week. So just a little preview there of what's up for you. But I'm really interested by this question of hope, because I can't always regulate my feelings. Like, I feel a certain way, or it might depend on that I get enough sleep, or did I talk to you that day? So I'll say two things. One, I actually am hopeful, but I don't know that I think it's particularly relevant. I will say that Stacey Abrams once sort of now famously said, like, she's neither optimistic nor pessimistic, she is determined. And so I think if you are looking for and need hope, which is totally understandable, and you can't feel it, then I would say, like, stick with your determination. Because some days I wake up and I'm like, well, I'm just going to move to Iceland and start a knitting commune and, forget all this. And one day that might be true, but like, in the end, like, I am determined, right? If I can't feel hopeful, I am determined. But I will tell you why I don't even know that it's hopeful, like, that we will win this. I am confident that we will win this. And I'll tell you why. One, we are right. Now, right doesn't always win, but like, we are right here, but we are also in the vast majority. And the sea change that has happened on abortion might seem obviously really counterintuitive, because we've lost Roe and Casey, which were the floor. And there are people who are so vitriolic, and the anti-rights movement is so much more empowered and vitriolic and violent. So it can feel like we've actually lost. But the sea change on how we talk about abortion and the way that we think about abortion is huge, even from when I was in high school in the 90s, which were great. Like, the way that, like, that change is gigantic. Like, the way that people, sort of normal everyday people, think about abortion is changing and has changed. And the majority of Americans, now depending on how you ask, whatever, people are on a spectrum, but the vast majority of Americans do not support restrictions on abortion, rollbacks on abortion. They do not support abortion bans. Now, are they all the way where I'd love them to be in terms of total compliance with international human rights law and standards? Like, no, but we're going to get there, right? So that's the first thing. Like, I am confident we will win. It will take a lot more work than I'd like, and I'm very tired, and you will be very tired, but like, we will win. And we will win because, like, the wins of people who have fought much harder battles than us are behind us. As Jamie was pointing out, in Latin America is a lot of really great examples where, like, I think we think about, I'll just say myself, you think about American progress and exceptionalism, and you think you've sort of shaken yourself of this type of American exceptionalism, but then this happens and it's like a death blow to me, right? Well, our colleagues in different country contexts and in states and in communities where they have not had access to abortion despite Roe, like, they've been fighting this battle, and they know they're going to win, and that's why they keep fighting, and we have won. So despite this massive and very real and impactful setback, like, we will keep fighting and we will win. I hope it takes shorter than longer, because there are real people's lives in the balance. But there's so many ways to do that, whether even the local movements that have happened around community care and people, like, picking up the pieces in local, I live in DC, and the local, like, group of people who are on a listserv. So if anyone needs a ride from another more, state, like, those types of things are popping up because people are going to put in the work to win. So I don't know if it's not overconfidence. I'm a pretty cynical person, and I don't know if it's feelings of hope, but like, we have seen how this goes, and we will win. We just have to keep putting in the work, and our job is to keep putting in the work until we can't do the work anymore, and then someone will come behind us and put the work in again. That's how we've won before, and it's how we'll win every time.
Thank you. That is pretty hopeful to me. We're right, and we will win. So thank you so much for this wonderful conversation. I just put a link in the chat to the others in this reproductive justice series. I encourage all of you to tune in. Thanks to our wonderful audience, and thank you to Tara, Macarena, and Jamie for this really, really rich and enlightening conversation. Thank you.
Thank you. Bye.
Thank you. Bye.